testing my microphone.
Ooh. Can you hear me now?
It worked. Can you hear me now?
I heard you. That's good. Excellent. Whoa.
Okay, it goes down.
Okay, hopefully everyone can understand me well. We'll call the October 4th Tax Commission meeting to order. Tina, could you go ahead and call roll for me, please?
Yes. Commissioner Lippman,
Present.
Commissioner Bursey,
I'm here.
Commissioner Brown,
Present.
Commissioner Wren,
Present.
Commissioner Byram,
I'm present.
Commissioner Witt,
Present.
Commissioner Johnson is absent today, and Chairman DeVolt.
Present. Okay, very good. At this time, I'd like to call for public comment. Anyone that would like to provide public comment, if you're not in person, please dial 9 to be placed in the queue. Tina, let me know if there's any public comment, please.
Thank you. Dial *9 if you're on the telephone. If you're in Zoom, please raise your hand for public comment. I don't see any public comment.
Okay, very good. Executive Director Hughes, would you administer the oath to all those that plan to testify today?
Yes, thank you. For those all present and on the Zoom call, by testifying today, you are swearing to tell the truth and the whole truth in the proceedings here today. Thank you.
Okay, very good. Next item is the meeting minutes. Is there any additions or corrections to the minutes of August 16th, 2020 Nevada Tax Commission meeting? If not, could I get a motion to approve those minutes?
Commissioner Brown moves to approve.
Commissioner Witt, second.
Motion and second. All those in favor, please signify by saying aye.
Aye. Aye.
Aye.
Anyone opposed? Okay, very good. Next item is the consent calendar. We've got one item that, item D1, Jonathan Snyder, will be continued to the next meeting. We need to work out some logistical issues and we'll get him on the consent calendar for the next meeting, please. Is there any other items that any of the commissioners would like to pull from the consent calendar other than item D1, Jonathan Snyder?
Commissioner Witt, item B6, Greenlight National, I have a question.
Very good. Any other items? Okay, could I get a motion to approve the consent calendar, please? With the exception of item B6, Greenlight National, and D1, Jonathan Snyder.
Commissioner Brown moves to approve the consent calendar with the one exception of B6.
Second, Commissioner Witt.
A motion by Commissioner Brown, seconded by Commissioner Witt. All those in favor, please signify by saying aye.
If Chairman, I don't think Commissioner Brown accepted D1.
Oh,
I was removed. I can amend it if it needs to be amended.
So I don't know procedurally if in any case, both of them are.
Could you restate your,
Thank you.
maybe just restate the motion, Commissioner Brown, accepting those two items?
Sure. Move to approve the consent calendar with the exception of B like boy, number 6, which was pulled by Commissioner Witt, and D number 1, which was removed to be processed at a subsequent meeting.
I'll second that motion. Thank you, Commissioner Brown and Chairman DeVold.
Okay, I've got a motion and second. All those in favor, please signify by saying aye.
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 Anyone opposed? Item B6, Greenlight National LLC. Commissioner Witt.
Yeah, on page 46, what I noticed was under fees and security deposit, it says estimated total monthly receipts is 400,000. Estimated total Nevada monthly taxable receipts is only 500. As I looked at all these other voluntary disclosures, this one just, I don't know why it jumped out. I don't know if anybody, I mean, I'm sure everybody looks at them, but it just seemed odd that they would have that much. And then I'm thinking of glittering LED lights in Las Vegas. And so I want somebody to reassure me, because there's other information prior to that that gives us a little bit more information as far as the tax related penalty and interest. So they paid $14,309.55, but that doesn't make sense with that other dollar figure of only 500 taxable sales.
I'm wondering, is Melissa Gardner on the phone or on Zoom?
Melissa is actually, Jennifer Roebuck should be on for Melissa. Jennifer, if you're on the telephone, dial *6, otherwise, raise your hand. Oh, here she is. Okay. Jennifer, go ahead. Thank you.
Can you hear me okay?
Yes,
Yeah.
we can.
Thank you. Sorry about that. Good morning, Chairman and Commissioners. This is Jennifer Roebuck, Tax Manager for the Department for the record. As Melissa Gardner is out today, I'll be answering on her behalf. With regard to your question about Greenlight National LLC, this voluntary disclosure appears to have been based on reported amounts. The taxpayer had a large sale, and in more recent periods, the taxable sales are actually around $500. So it looks like it was a one-time situation where they did have a large sale at the time.
Okay. Yeah, the others just kind of make more sense. Sometimes that jumps out. So yeah, if it was a large sale, then that would make sense why those would be such a difference. Okay.
Sure.
So I would move to go ahead and approve Greenlight National LLC.
Commissioner Wren, second.
I've got a motion by Commissioner Witt, seconded by Commissioner Wren. All those in favor, please signify by saying aye.
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 Is anyone opposed? Okay, very good. Director Hughes, Division of Local Government Services.
Yes, agenda item 4, Division of Local Government Services. Agenda item 4A, Taxpayers Appeal of the Treasurer's Denial of Waiver of Penalty and/or Interest per NRS 361.4835. The first item is Shuju Yu for possible action. And we have Jeff Mitchell for the department, and I think we have both parties on the line.
Shoji, if you are on the line, please, if you're on the telephone, dial *6. If you're on Zoom, please raise your hand. I believe Kevin Yu was going to appear on this matter, and we have a interpreter on the line as well.
Yes, ma'am.
Could the interpreter slowly spell the names of everyone, including yourself?
My name is Echo, ECHOLIM. I do not have the name of the person who's I'm supposed to interpret for.
Okay, so this is the taxpayers' appeal, so they can go ahead and make their case as you see fit.
Chairman, okay.
好的，请问这位先生或者女士，您需要就是现在可以通过翻译帮您上诉，您在线上吗？
I don't see Mr. Yu on Zoom or on the telephone.
尤先生，你在线上吗？
If Mr. Kevin Yu is on the phone, please dial *6. If you are on Zoom, please raise your hand.
尤先生，如果你在电话线上的话，请您点星6。如果您在 Zoom 线上的话，请您举手。
I do not see him on there.
Mr. Mitchell, is this a case that you would like to continue until we get the taxpayer on the phone, or what's your preference here? Would you like to make your case and we can make a decision? I kind of feel like we need to hear from the taxpayer.
I did speak with Mr. Yu last week, and he did say he was going to appear on behalf of his parents. So I don't know.
What happened, huh? Would the other commissioners be okay with continuing this case to the next meeting?
Yes, please.
Could someone make a motion to that effect?
Commissioner Lippman moves to take the matter from the October agenda for the matter of Taxpayers Appeal of the Treasury's denial of waiver of penalty and interest for Shu Zhu Yu, and continue it until the next meeting.
Mr. Chairman, would it be possible to hold off until the end of this meeting and see if perhaps he comes before this meeting is over? I'm not sure if that works for the interpreter, but if we could wait and then at the end of this meeting, see if he has arrived and maybe she can contact him before we postpone it to the next meeting.
Yeah, that's fine. That's fine. Commissioner Lippman, would you withdraw your motion if that's agreeable?
Yes, I'll withdraw the motion. Thank you.
Okay, we'll move this item to the very last agenda item then, and we'll see if they show up. And thank you to the interpreter for staying with us. Appreciate it. Okay.
Yes, I will stay online.
Okay, thank you very much. Okay, Director Hughes, the next item.
Agenda item 4B, determination and allocation of certification of centrally assessed 2022 to 2023 secured and 2021 to 2022 unsecured unitary property valuations and assessments pursuant to NRS 361.320, NRS 361.321, and 361.323. For possible action, we have Soren Popa representing the department.
Good morning, Mr. Chairman, members of the Commission. My name is Soren Popa, and I'm the supervisor of the Centrally Assessed Properties Division of the Department of Taxation. Before you is the 2022-2023 secured roll and 6-month QIP, as well as the 2021-2022 unsecured roll and 12-month QIP. Based on information provided by taxpayer pursuant to NRS 361-318, as well as other research, to verify data conducted by the utility analyst at the department, we have established the taxable and assessed value of property for an interstate and intercounty nature for review and approval by the Commission. A few days ago, after submitting the report to you, we learned that a private car line, ECDC Environmental, the number 683, inadvertently reported an incorrect mileage, which led to a small change in the assessed value from $32,143.84 to $19,018.47, leading to a total assessed value change for car lines from $4,321,425.09 to $4,308,299.72. If you would like to certify the new value, we will process it promptly. Otherwise, we will handle it administratively. Centrally assessed industries operating within the state of Nevada include airline companies, electric companies, gas and pipelines, railroads, private rail car lines, and telecommunication properties. If you wish, I could either provide summaries by industries, or I can go company by company or answer questions. I will defer to you.
Why don't we go to answer any questions that any of the commissioners have? Thank you, Mr. Popa. Is there any questions of Mr. Popa?
Mr. Chairman, it's Commissioner Brown. It's not a question, but it's just a disclosure to mention that I work for a telecommunications company in this state. It's not centrally assessed, but it affects my company no differently than any other. I'll be voting on the matter.
Thank you, Commissioner Brown. Any questions or comments from Mr. Popa?
Commissioner Lippman, Mr. Popa, you indicated that you could handle the estimate change administratively. Could you clarify that? I didn't understand what you were referencing.
So, Jeff,
Commissioner Lippman, if I may, this is Jeff Mitchell, Deputy Director of Local Government Services. So how we would handle it administratively is we would have to appeal our own value to the State Board of Equalization in January and then go through that appeal process to change that value rather than correcting it here. That's how it would be handled administratively.
Thank you.
Mr. Chairman, if I may.
Yes,
I
Commissioner.
would like
Brown.
to. I would make a motion to approve the centrally assessed manual with the correction noted by Soren Popa.
Commissioner Bursey seconds.
Okay, I've got a motion by Commissioner Byram, seconded by Commissioner Bursey. All those in favor, please signify by saying aye.
Aye.
I,
Anyone opposed, same sign. Thank you, Mr.
thank you.
Director.
The next item is agenda item 4C, review and consideration to amend previously adopted Bulletin 211 for 2022-2023 agricultural land values and open space property procedures to include tables relating to the valuation of open space golf course land and improvements. We have either Jeff Mitchell or Cheryl Erskine for the department.
Good morning. This is with the Department of Local Government Services. Good morning, Mr. Chairman and members of the Commission. This is Cheryl Erskine, Coordinator of Assessment Standards for the Local Government Services. This morning, I'm going to present the 2022-2023 Golf Course Table Addendum to Agricultural Bulletin number 211, which was approved by this Commission on May 3rd, 2021. This addendum is prepared in accordance with NRS 361A.225 and is being presented now due to the Consumer Price Index tables published by the Bureau of Labor Statistics not being updated until after July of this year. This prevents LGS from updating golf course land values in time for the May Tax Commission hearing for consideration and approval with the Agricultural Bulletin. As you can see in the first table, the land value of golf courses is calculated by considering the July 2021 CPI amount of 289.863, which results in a factor of 1.50. When this factor is applied to the 2004 taxable per acre value, you get this year's taxable per acre value of $4,290. This proposed value increase results in a 1.04% change over last year. The second table shows this year's Marshall and Swift factors, which are used in valuation of golf course improvements throughout Nevada counties. The third table lists golf course rating points assigned for par readings to be used to determine whether a course is a class 1, 2, 3, or 4 pursuant to NAC 361A.4410. The tables on page 2 list per hole costs and individual components that could be located at a golf course, such as storm drains, bridges, and water features. At this time, we would like to request approval of the Golf Course Addendum to Agricultural Bulletin number 211 for 2022-2023. I'd be happy to answer any questions you may have.
Thank you, Ms. Erskine. Are there any questions from any of the commissioners? Is there a motion to approve?
Mr. Chairman, I move to approve the golf course updates to the bulletin 211 for 22-23 ag land.
Thank you. Okay, I've got a motion by Commissioner Byram and a second by Commissioner Wren. All those in favor, please signify by saying aye.
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 Anyone opposed? Very good. Director Hughes, next item.
Agenda
Mr. Chairman,
item 5 is Compliance Division.
Yes, I'm sorry.
Oh, sorry.
Commissioner Brown.
I'm sorry to interrupt, Commissioner. I just wanted to mention, it looks like there are folks still on the line that had items that were approved on the consent calendar. I don't know if they would like to continue to listen, but
Thank you. If there's anyone on the agenda that has anything on items 3, A, B, C, D, items have been approved. So if you're on the agenda under the consent calendar and you're still on the telephone, you're more than welcome to stay for the commission meeting, and we would be happy to include you. But if you've got other things to do, your item has been approved. Thank you, Commissioner Brown.
Pardon me, hi, this is Paul Conigan. Can you hear me?
I'm sorry, I didn't catch that.
My name is Paul Conigan. I don't know what agenda item my client is or what number it is and whether it's been approved on the consent agenda. And so I'm here, but I'll stay, of course. I just want to make sure that I'm not on the consent agenda for Shafiq Brown.
He's next on the agenda.
Okay, thanks so much. Sorry.
Okay, so moving on, agenda item 5, Compliance Division. The department's recommendation to the commission for denial of an offer in compromise pursuant to NRS 360-263. The first item on that agenda is Shafiq Brown. And for the department, we have Adrian Roberts Larson. And the taxpayers representative is on Zoom.
Good morning, Mr. Chairman and members of the commission. Adrian Roberts Larson for the record. Shafiq Brown of Gizmo Empowered and S550 Investments has submitted a request for an offer in compromise. The offer and compromise packets were submitted incomplete as Mr. Brown did not provide an explanation for his request or the periods for which he is asking to compromise. The combined offers to pay a total of $2,000, $1,000 each for each account, and the reason is based on doubtless collectability. A review of the accounts and department research revealed that the following businesses of Gizmo Empowered is open and operating. Mr. Brown is associated with multiple open businesses, and the offered amount is unreasonable. Shafiq Brown has provided documentation to support that he's receiving unemployment. However, he is 26 years old, has future earning potential. Mr. Brown has an established history of noncompliance with the department and blatant disregard of Nevada tax laws. He has been the president of at least 9 businesses, of which all 9 have a tax balance owing to the state. He is also associated with another 4 businesses, of which 3 are open and operating. The total balance owed for all 13 businesses with tax calculated is a total of $1.7 million and tax is $1,258,480.55. Therefore, it is recommended that the Nevada Tax Commission deny Mr. Brown's request, and the department is prepared to continue pursuing collections against Mr. Brown. Thank you. I'm happy to answer any questions that you might have.
Thank you, Ms. Roberts Larson. There is a representative for Mr. Brown. Could you state and spell your name for the record?
Yes, my name is Paul Conigan, C-O-N-N-A-G-H-A-N. I am appearing for this hearing only because Mr. Blute, the representative of the taxpayer, is unavailable today. Elliot Blute, he's the attorney for Mr. Brown. So I'm only appearing as an alternative or substitute for this hearing only.
Okay, very, very good. The department is recommending that we deny the offer and compromise. Do you have anything to add to the conversation?
No, I don't.
Okay. Is Mr. Brown Shafiq Brown on the telephone?
He is not.
Okay. Is there any questions of the department or Mr. Paul Conigan, the representative of Mr. Brown?
Mr. Chairman.
Thank you.
Yes, Commissioner Byram?
Thank you. Mr. Chairman, does the state have an agency authorization on file for Mr. Conigan?
This is Adrienne Roberts Larson. We do not for Mr. Conigan, however, we do for Mr. Blute.
I
And
don't
I'm with
believe
his
that.
firm. I'm with his firm. I'm an attorney. So
I understand that, and without the written authorization, I don't believe you can represent him for this hearing. But I would defer to our counsel.
well then, okay, that's fine. And then can you continue this matter, and then also the findings and so forth that were set forth and recommendations, all the information related to that. Would you please produce that to Mr. Blute?
Again, Adrienne
Mr.
Roberts.
Chair,
I'm sorry.
go ahead.
Adrienne Roberts Larson for the record. I would like to point out that the department sent a letter with our recommendation to deny to both Mr. Brown and Mr. Blute on August 2nd, to which neither of those parties responded. And we did confirm that they were sent to good addresses, as the notice was sent to Mr. Brown at his notice DMV address, and to Mr. Blute at his office here in Las Vegas.
I don't know that he has those. I'm sorry, this is Paul Conigan. May I briefly just chime in here for one more thing?
Yes, please.
I don't know that Mr. Blute has that. I don't know that Mr. Brown has it. I don't deny that those were sent at all. I don't challenge that. But as a courtesy, I would ask if you can email those to Mr. Blute. I would appreciate that, or he would, I'm sure. I would believe that he would have provided that if he had it to me, because he did provide me with certain information ahead of this hearing. So is there a way that you can email that to him to be sure, or email it to me so that I can be sure that he gets it?
Mr. Conigan, this is Adrienne Roberts Larson. Yes, I would be happy to, after the hearing, to discuss with Mr. Blute any information that he might be in need of. However, I would ask that the commission not continue this so that the department can timely move forward with continued collections. Again, I believe that we've put before you today a presentation that clearly shows that Mr. Brown is habitual in his noncompliance, and that the state is ready and willing to move forward with any actions that we can to recoup the money that is owed to the state. Thank you.
I appreciate your position, counsel. I assume that I'm speaking with legal counsel, and I appreciate your position. However, you've sought to nullify my appearance by setting forth that I'm not authorized, although I'm confident that Mr. Blute and his law firm is authorized, and I am working in affiliation with them. I am an attorney, but if you are taking the position, if you're going to insist on your position, and if the commission is going to accept your position that I'm not authorized to appear here, then basically you're depriving the taxpayer of counsel in this hearing and asking for a ruling to be made. And I'm telling you that Mr. Blute does not have that information, or at least I don't believe that he does, that you've referenced. So if you can compromise and at least recognize my appearance, if you're going to make a ruling, that's fine. Or if you're going to challenge my authority to appear, then I think there's good grounds to go ahead and continue this to another date when Mr. Blute can be present.
Mr. Chairman, this is Commissioner.
Yes. Commissioner Wren, we can't hear you.
Sorry, this is Commissioner Wren. I'd like to move forward. I'd also like to point out that Mr. Brown's representative has already stated that he has nothing to add, so I'm not sure why he's here.
Thank you. Commissioner Byram, did you have something as well?
Yeah, I would state, just for purposes of this hearing, that I'm going to waive any objection to the representation by Mr. Conigan, and I'm going to move to uphold the denial of the offer in compromise for Shafiq Brown.
Commissioner Wren, second.
Okay, I've got a motion by Commissioner Byram, a second by Commissioner Wren to uphold the department's recommendation for a denial of the offer in compromise. For Mr. Conigan, that does not mean that this is forever. Come back with another offer in compromise that's reasonable and work with the department would be our recommendation. So with that commentary, is there any other discussion?
Mr. Chairman, it's Commissioner Brown. I would just put on the record that I concur with the department's recommendation, and I would support them pursuing a responsible person designation against Mr. Brown, as well as revoking the seller permits of all associated businesses that are operating today.
Very good. That's not on the agenda today, but we do have an offer in compromise and a motion. Is there any other commentary? All those in favor, please signify by saying aye.
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 Anyone opposed? Very good. Offer in compromise is denied. And I would fully support Commissioner Brown's recommendations. It sounds like we've got someone that's getting pretty far ahead of us here on the tax side, and he's unresponsive. So Mr. Conigan, could you please contact the department and see if we can't get some kind of a resolution before this gets any worse for your client?
I will pass that along to Mr. Blute.
Thank you so much, sir. Thanks for your time today.
Thank you.
Thank you, Brian.
Director Hughes, next item.
Agenda item 5B, approval of refund credit requests in excess of $250,000. Item number 1, National Union Fire Insurance Company of Pittsburgh, Pennsylvania. For the department, we have Jody Tonkin.
Good morning, Chairman and Commissioners. My name is Jody Tonkin. I'm a tax program supervisor for the department. Today, the department is recommending approval of a credit refund in the amount of $482,199.58 for overpayment of insurance premium tax by National Union Fire Insurance Company of Pittsburgh, Pennsylvania for the tax year 2020. After processing the taxpayer's reconciliation return, for the year 2020, the department reviewed and verified the taxpayer filed and paid their quarterly insurance premium tax returns timely. However, they overreported and overpaid their returns for March of 2020, September of 2020, and December of 2020 periods. Additionally, the taxpayer did not apply their Property and Casualty Guarantee Association credit or their life and health credits throughout the tax year. The discrepancy was discovered by the taxpayer when they filed their annual reconciliation return for the 2020 reporting period, resulting in an overpayment and refund request in the amount of $482,199.58. And I'm available if you have any questions.
This seems like a repetitive thing with the insurance company.
It sure is.
Well, thank you for your efforts on that behalf. Is there any questions of Ms. Tonkin?
Mr. Chairman, Commissioner
Yes.
Byram, the majority of this refund is based on error by the taxpayer that they should have had the information. And I just wanted to make sure that it doesn't include interest to them for their error.
Jody Tonkin, for the record, Commissioner Byram, it does not include interest.
Is there a motion to approve?
Commissioner Lippman moves to approve the refunds in excess of $250,000.
Okay, this is just for item B1.
Oh, thank you. For National Union Fire Insurance Company of Pittsburgh, Pennsylvania.
Thank you, Commissioner Lippman.
Commissioner Byram, second.
Got a motion and second. All those in favor?
Aye.
Aye. Aye.
Aye.
Anyone opposed, same sign. All right, very good. Ms. Talkin, I'm guessing you have the next one as well.
I do. So today, the department is recommending approval of a credit refund in the amount of $565,473.48 for the overpayment of industrial insurance premium tax for Markel Insurance Company for tax year 2020. After processing the taxpayer's reconciliation return for the 2020 year, the department reviewed and verified the taxpayer filed and paid their quarterly industrial insurance premium tax is timely. However, they did not apply their Division of Industrial Relations credits to the quarters ending March 31st, 2020, June 30th, 2020, September 30th, 2020, and December 31st, 2020. This discrepancy was discovered by the taxpayer when they filed their annual reconciliation return for the 2020 reporting period, resulting in an overpayment and a refund request in the amount of $565,473.48. And I'm here for any questions.
Any questions?
Commissioner Lippman, is there a mechanism for this overpayment to be applied to future years rather than refund it and then have, it seems like this is administratively burdensome.
Yes, this is Jody Tonkin, Commissioner Lippman. The taxpayer can take this on a future period, and when we run into this circumstance, we do reach out directly to the taxpayer to see if it is something they would like to do. In this case, the taxpayer did want the refund back.
Thank you.
You're welcome.
Is there a motion to approve?
Commissioner Lippman moves to approve the refund in excess of $250,000 to Markel Insurance Company.
Commissioner
Second by
Bursey seconds.
Commissioner Witt.
Yeah, I think I heard Commissioner Bursey first, so I've got a motion by Commissioner Lippman, seconded by Commissioner Bursey. All those in favor, please signify by saying aye.
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 Anyone opposed? Very good. Director Hughes, next item on the agenda, please.
Agenda item 5C, petition for reconsideration of department's denial of exemption status for organization created for religious, charitable, or educational purposes. NRS 372.3261. Item number 1 is the Folded Flag Foundation. We have Andrea Nichols from the Attorney General's office representing the department, and I believe we have the taxpayers representative, Michael Cabrera, is on Zoom.
Ms. Nichols, is there a chance that we could expedite this one and maybe get it? It sounds like we are very close to being able to grant this exemption and move forward, that there's a couple of pieces of documentation that we would need from Folded Flag and we move forward. Would you be in agreement with that? In an attempt to expedite it rather than go through, because this obviously looks like a fantastic organization that we want in the state of Nevada. Would you?
Yes, yes, Chairman, sorry.
I'm not that big of a deal.
The department did deny this one because of lack of information, and it was originally set for the last tax commission meeting. It was continued, and at the last minute, they provided some more financial information, but really what the department would want to see is something showing that they're actually providing charitable services in Nevada. And if you look, the exhibit or the documents that they submitted show a lot of expenditures for office supplies, professional costs, that type of thing. But there's nothing showing that they're actually providing anything charitable in Nevada currently. And if they would show that, if you want to remand it back to the department, if they'd produce that, then I would imagine it would be granted.
Mr. Cabrera, You on the Zoom call, is that something that you could easily provide financial statements and just proof that you're providing support to Nevada residents, I guess? Is that a good?
Yes, and can you hear me now? Are you able to?
Yes, we can. Thank you.
Okay. We've provided quite a bit of information. We went through the statute and explained how all of the things, all the different items are met. Additionally, we provided a copy of the IRS Form 990, which demonstrates a lot of the questions that the department had. And we've provided a list of all the expenditures that are being made in Nevada. In my view, I think that you have enough before you to outright approve this, but if your preference is to send it back to the department for additional consideration, we can go ahead and provide whatever information that the department has is in need of. And, in my view, we've been asking over the last few months, what do you need from us to demonstrate that we are a Nevada nonprofit that is worthy of the sales tax exemption? And we have not received a response until just now. I'm just hearing over in the Zoom really what you're looking for. So we understand now that you're looking for Nevada specific services being provided. I think that we've done that, but if you need something more, we can circle back with you and provide that to the department.
I think if you could do that for us, it would not come back to the tax commission. It would merely be approved through normal channels through the Department of Taxation. So if you're willing to provide that information, like I say, I think we want you in Nevada. I like what you do a lot. Obviously, it's a fantastic organization. And if you could just help us with those few pieces of information, we'd appreciate it.
And may I just inquire, are we looking for who in Nevada received scholarships, like that level of detail? Yes, okay, I see Commissioner Littman nodding, so, okay. Very good.
I would point the chairman and commissioner to NAC 372-700, which requires that they provide financial information, which provides verifiable sources of income and expenditures. And we would also just be really looking at Nevada specific information. And it's not anything that the department wouldn't ask of any other organization.
So, Ms. Nichols, could you do me a favor and maybe give the applicant a specific needs list, if you would? Hey, here's what we need. And if you don't mind maybe emailing it or mailing that to him, that would be terrific. And you can move on and so can they. Thank you.
Thank you.
So with that, could I ask for a motion to remand this back to the department for further documentation and potential approval?
Mr. Chairman, it's Commissioner Brown. I completely agree with your sentiment. I think it is an organization that we want in the state that is doing work in the state and across the country for that matter. But I would support that. I would make a motion to remand this back to the department.
Commissioner Littman seconds the motion.
Got a motion and second. Any further discussion? All those in favor, please signify by saying aye.
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 Anyone opposed? Thank you, Ms. Nichols. Thank you, Mr. Cabrera. Good luck.
Thank you.
Director Young, next item. Hughes. Did I just do that?
That's okay.
I apologize. It's probably going to happen again. I apologize.
Agenda item 5D, Taxpayers Appeal of Administrative Law Judge's Decision pursuant to NRS 360.245 and NAC 360.175. Item number 1, Wesco Distribution LLC. And we have Hillary Bunker from the Attorney General's office representing the department. And I believe we have a petitioner on Zoom or on the telephone.
Is there a representative of West Coast Distribution on the telephone?
Both counsel as well as corporate representative. This is Richard Schoenfeld, attorney for Wesco Distribution LLC, and your Bitar corporate representative is also on the telephone or on Zoom.
Okay, thank you very much. This is your appeal, Mr. Schoenfeld, so go ahead and make your case, please.
Thank you. On June 7th, 2021, the department seized the other tobacco product at issue, which I'll refer to as OTP throughout my argument, citing Nevada Revised Statute 370.567 and 370.585. And you can find that at the record of appeal at page 32. We did lodge the record of appeal as well as the transcript designation for purposes of the petition that we are pursuing the appeal today. At the administrative hearing, the department acknowledged and the investigator testified that the basis for the seizure was that the appellant, Wesco Distribution LLC, was allegedly using a company called T-Force Logistics as an unlicensed logistics company, and therefore the OTP was subject to seizure, and ultimately the department is seeking to destroy that property. Under Nevada Revised Statute 370.547, a logistics company is expressly defined, and the definition of a logistics company is a company that is authorized by a wholesaler of OTP to, quote, temporarily store, fulfill orders for, and coordinate the transport or delivery of OTP. And so when we look at that statute, there's three requirements in order for a company to be deemed a logistic company. A company has to temporarily store, has to fulfill orders for, and has to coordinate the transport or delivery of OTP. Those are in the conjunctive as written in the statute. The testimony presented by the investigator at the administrative hearing was that the department seized 17 pallets of OTP that belonged to Wesco Distribution from the T-Force Logistics location, and that the value of the seizure was $272,971. The testimony further established that had the OTP been located at Wesco's warehouse, it would have been perfectly legal and not subject to seizure. So in other words, the alleged or purported impropriety here is that it was located at T-Force's warehouse as opposed to Wesco's warehouse. The investigator asserted that T-Force was acting as a logistics company because it would receive the shipment for Wesco from Mecca Enterprises, the seller of the product to Wesco. And the term utilized by the investigator was that T-Force would, quote, receive the load, end quote. And that's found at the record of appeal 105, which is a portion of the transcript. Pursuant to the testimony at the administrative hearing, the only activity engaged in by T-Force was removing the OTP from the Mecca shipping truck and then storing it temporarily at their warehouse for Wesco to later retrieve. And that's found at record of appeal 117 to 118, which is also the transcript of the investigator's testimony. The investigator further acknowledged that had the load been delivered directly to Wesco's address, there would have been no violation or basis for the seizure, and that's at page 115. The investigator testified that the basis for the seizure was Nevada Revised Statute 370.5673C, which is, as I've stated, the definition of a company acting as a logistics company. So in order for the OTP to be considered contraband, T-Force Logistics had to in fact be operating as a logistics company. However, the testimony was clear that that is not what T-Force was doing. The investigator acknowledged that T-Force did not fulfill orders for Wesco, nor did T-Force ship the OTP to end purchasers for Wesco. And that's found in the record of appeal at page 132. The testimony was, quote, a truck would pull up with OTP and T-Force would assist with Wesco in fulfilling orders by temporarily storing the product. And so when we look at that, the investigator equated temporary storage as also assisting in the facilitation or filling of orders, when clearly that's would make the statute redundant. All Wesco allegedly was doing is utilizing T-Force to remove the product from a truck, temporarily store it at that location, which does not meet the definition of logistics company because, as admitted by the investigator, Wesco was not fulfilling orders nor coordinating the transport or delivery of the OTP. It was simply receiving the orders and temporarily storing them. The witness acknowledged that the removal of product from the truck and storing it, which is something they claimed that Wesco customarily did, with partial loads, and then T-Force would return, then West Coast would return to T-Force to retrieve that property a couple days later, would only amount to temporary storage. That is the only evidence in the record of what Wesco Distribution did with T-Force. And as the commission knows, in order for the administrative law judge's findings to be upheld, there has to be substantial evidence in the record to support those findings. So when we go back to NRS 370.547, in order to seize the OTP as noticed by the department, and the notice of seizure is included in the record of appeal, T-Force would have had to have done more than temporarily store. They would have had to also fulfill orders for and coordinate the transport or delivery of the OTP. There is no evidence of those activities. As a result, when we get to the legal argument here, the administrative law judge chose to ignore the plain language of the statute and instead found that temporary storage was in and of itself sufficient to deem that the property at issue became contraband because the T-Force was acting as a logistics company merely by temporarily storing the product, and that there was in fact no requirement that evidence be produced to establish fulfilling orders for and coordinating transportation, as the plain language of the statute states. So now, as a backup and also in the administrative order, which really is an acknowledgement that there wasn't a basis for the seizure, the administrative law judge cited NRS 370.575, which was not one of the basis for seizure on the notice of seizure that was provided to Wesco, which generated these proceedings. And in that statute, what the administrative law judge was finding is that when Wesco applied for licensing or for renewed licensing with the division, it would have been required to list the address where OTP was going to be stored. And because the OTP was located at T-Force, Wesco therefore did not properly list where the OTP would be stored. That was not the basis for the seizure, and the notice of seizure specifies the two statutory bases, and that's at Record of Appeal 32 as NRS 370.567 and NRS 370.585. So the backup position taken by the administrative law judge is under NRS 370.575, not one of the statutes cited. Moreover, NRS 370.575 does not authorize the seizure of OTP as contraband, nor does it authorize the destruction of that seizure. So it really, as I said, is almost an acknowledgement that the evidence does not support that T-Force Logistics was in fact acting as a logistics company as it relates to Wesco. So the administrative law judge found another basis, which under the law isn't supported, in order to authorize the continued seizure and destruction of the property at issue. So at the end of the day, not only is there insufficient evidence in the record to support the findings that T-Force acted as a logistics company, there's insufficient authority under the law to seize and destroy the property under NRS 370.575. But it also boils down to a violation of the 8th Amendment to the United States Constitution, which prohibits excessive fines and penalties. And I cited both at the administrative law judge level as well as my opening brief for purposes of this commission appeal, both the 8th Amendment and the seminal case on the 8th Amendment, which actually came out of the 9th Circuit Court of Appeals, which is the circuit that governs our federal courts here, and went all the way up to the United States Supreme Court. That case is United States versus Bajakajian, and that's Bajakajian, found at 524 U.S. 321. It's a 1998 case out of the United States Supreme Court. In that case, an individual was transporting $357,000 outside from the United States to a location outside of the United States. And under federal law, when there's a transportation of more than $10,000, it has to be declared. That individual was accused of not declaring the $357,000, which was clearly in excess of the $10,000 when leaving the country. As a result, the United States government seized that property and tried to forfeit it. The court found that forfeiture of $15,000 as opposed to the full $357,000 would be more appropriate, because seizing and forfeiting a full $357,000 for the type of violation that the individual was accused of, which was a reporting violation, would be an excessive fine and would not be rationally related to the alleged illegal conduct at issue. And so when we take that US Supreme Court case that recognized that forfeiture is in fact considered a fine under the excessive fines and penalties clause, and we look at the facts of this case, whether it be that that Wesco failed to list TCO's address as a warehouse facility, or whether it be that the finding that T-Force Logistics is in fact a logistics company, which is inconsistent with the plain language of the statute. Either way, it would be excessive to forfeit and destroy the $272,000 worth of OTP that would have been perfectly legal for Wesco to have had delivered directly to its warehouse, as opposed to temporarily storing it for 3 days at T-Force. It would be an excessive fine or penalty to take away that $272,000 worth of OTP from Wesco distribution, and that would be a violation of the 8th Amendment prohibition against excessive fines and penalties. Lastly, I will just note that the Nevada Supreme Court has recognized, going back to the definition of logistics company under 370.547, that judicial review is appropriately granted in cases where the administrative forum does not recognize the plain language of the statute. And what the cases say is, it is well settled that where the language of a statute is plain and unambiguous, its meaning clear and unmistakable, there is no room for construction, and the courts are not permitted to search for its meaning beyond the statute itself. And when we look at the plain language of 370.547, it is in the conjunctive: temporarily store, comma, fulfill orders for, and coordinate the transport or delivery of OTP. In this instance, the evidence only supported the temporarily store and not the other requirements necessary to find that T-Force Logistics was in fact a logistic company related to the services being provided to Wesco Distribution. And there was a case that the Nevada Supreme Court granted judicial review for in the State Department of Employment Training and Rehabilitation versus Reliable Healthcare Services, where the Supreme Court noted, because we conclude that the board's determination pursuant to NRS 612.085 was unsupported by the evidence presented and deviated from the applicable conjunctive statutory requisites, we affirm the district court order granting judicial review and reversing the board's determination. And while obviously that was a different statute than the one at issue here, the Supreme Court recognized that when the statute is written in the conjunctive, you cannot deviate from the applicable conjunctive statutory requisites, which is what occurred in this case. So as a result of that, I am requesting that the commission reverse the order of the administrative law judge related to the seizure, forfeiture, and destruction of the OTP at issue.
Thank you, Mr. Schoenfeld. Ms. Bunker, do you have a response, please?
I do. Thank you. Hillary Bunker from the Attorney General's office for the record. As has been mentioned, the OTP in question was the property of Wesco Distribution, who is a licensed OTP wholesale dealer in Las Vegas. There's no dispute that the product located at T-Force Logistics warehouse was OTP and subject to regulation by the department. And the hearing officer found that the OTP seized was properly classified as contraband, as T-Force Logistics did not hold any state-issued license that would have authorized it to possess OTP, and that Wesco itself failed to identify any statute which would allow an unlicensed third party, such as T-Force Logistics, to possess OTP, whether through a logistics service or not. At the original hearing, the department presented evidence of a long-established relationship between Wesco's owner and employees of T-Force Logistics, where there were over 100 transactions of cross-docking OTP shipments. The department has also continuously argued that even if Wesco's contention was that T-Force Logistics was simply acting as a storage facility, Wesco is not permitted to use a secondary unlicensed location for their wholesale business. The hearing officer found that Wesco offered no contrary evidence of its relationship with T-Force Logistics, no alternative explanations concerning the emails and texts from Wesco's owner to employees of T-Force Logistics, and no explanations regarding the unforeseen circumstances that resulted in 17 pallets of OTP being located at unlicensed T-Force Logistics warehouse, or how this transaction differed from prior shipments that had been sent to them. Most importantly, the hearing officer found that Wesco failed to address the crux of the issue that we have, identifying any statute which would have authorized an unlicensed business such as T-Force Logistics to possess Wesco's OTP. She found that whether Wesco used a logistics company or a warehouse service for its shipment of OTP, Wesco was required to use a licensed company, and Wesco failed to do so and instead placed its OTP with an unlicensed entity. As has been referenced, the notice of seizure cited to Wesco referenced 370.585. This lists the actions that a licensed OTP wholesale dealer is permitted to perform. These include purchasing OTP from an entity that manufactures or wholesales it, selling OTP, and temporarily storing and fulfilling orders for OTP at a licensed warehouse or distribution center or through a licensed logistics company. When Wesco's product was delivered and stored at T-Force Logistics, an unlicensed location, this was in violation of 370.585 subsection 3. Wesco's argument that T-Force Logistics was not acting as a logistics company and are under NRS 370 is attempting to draw away attention from the central issue. It is illegal under NRS Chapter 370 for Wesco to store OTP at a secondary unlicensed location. The department respectfully requests that the commission uphold the final decision issued by the hearing officer on July 14th. Thank you.
Thank you, Ms. Bunker. Mr. Schoenfeld, do you have a rebuttal? And then at that point, I'll go back to the commission for questions.
Yeah, I would just note that it's almost burden shifting, saying that we have to establish authority for the OTP to be located at T-Force. The division acknowledged that Wesco Distribution LLC was not operating the warehouse and therefore didn't have to have licensing to operate the warehouse. And again, if we look at the statute that relates to the definition of logistics company, the definition is threefold, and only one of those folds is reflected in the evidence. So there isn't substantial evidence in the record to support the findings. And really what we're looking at are the findings and whether or not they're supported by substantial evidence in the record. And finally, we didn't hear any response to the excessive nature that if there was an administrative violation in the form of not having listed the T-Force location as a warehouse or temporary warehouse facility, how that would support the forfeiture and destruction of $272,000 worth of property, and how that would not be considered an excessive fine or penalty under the 8th Amendment.
Thank you, Mr. Schoenfeld. Mr. Schoenfeld, I'm going to kind of get to the elephant in the room here now. So 100 times you're using an unlicensed warehouse to store product that you probably know that it's unlicensed, and it sounds like there's a cross-docking arrangement, and you're paying $5 in and $5 out to the employees. Why are you doing this? I don't understand where we're going in the first place. What's going on, and why are you not using a licensed logistics company to warehouse this OTP?
Sure. So the evidence at the hearing established that the requirements for an entity like T-Force to be licensed were not implemented until 2020. Wesco Distribution had been licensed long prior to that modification or amendment in the regulations. While the investigator used the terminology cross-docking, there was no testimony in support of cross-docking. Rather, what the evidence established was that Wesco would have, for example, in this instance, I believe it was 32 pallets of OTP, 17 of which were delivered to T-Force Logistics, and the remainder were delivered to Wesco's address. And it was just an issue of not having enough space in the Wesco warehouse to store all of the pallets as opposed to just part of the pallets. And the testimony established that historically what would happen is Wesco would retrieve its own product within days. So what happened here, the product was delivered on a Friday and it was seized on a Monday. So that was only a weekend that it had been there. So I don't believe there was evidence that it had happened hundreds of times, but to answer your question, the answer is that it truly was being used as temporary storage because there was not enough storage space at the Wesco address. And the investigator did testify that had it all been delivered to the Wesco address as opposed to only partial delivery there and then the other part to T-Force for temporary storage, it would have been completely lawful and not subject to seizure. So at the end of the day, if there is a finding that Wesco was not permitted to utilize T-Force to temporarily store this product, it really was just temporary storage. They were not using T-Force as logistics. T-Force, the testimony established, never shipped the product anywhere. It would come in from the Mecca truck, which was the company where it was purchased from in Florida. No suggestions of any impropriety there. It would be delivered to Nevada. The part that got delivered to the Wesco warehouse, no impropriety there. But the portion that Wesco didn't have enough room to store that went to T-Force, that's where these issues arise. And it would simply be stored there and then picked up by Wesco, not shipped by T-Force, not shipped to an end purchaser by T-Force, not picked up by an end purchaser, truly just temporary storage at the Wesco facility. I mean, at the T-Force facility.
Ms. Bunker, help me out here. When was this licensing procedure put in place? Was it before or after these instances were occurring?
Hillary Bunker, for the record, the licensure requirement for a warehouse or a logistics company became effective on January 1st of 2020. So the department's investigator was able to obtain text messages and invoices and bills of lading from 2019 through 2021. So we presented evidence to show that that T-Force Logistics was being used by Wesco both before the change in law and after. So one of as you referenced, the cross-docking description provided by an employee of T-Force Logistics itself, they defined it. This was not defined by the investigator, but T-Force Logistics said that they engaged in cross-docking with Wesco, that they allowed businesses to drop off product, pick up product, temporarily store it, adjust and reposition it to coordinate orders to assist in the delivery of these products. So while we would absolutely agree that the requirement that a licensed warehouse did not take effect until January 1st of 2020, that the taxpayer was in fact using it both before and after that change in law. And at the time of the seizure, it had been nearly a year and a half since that law was put into effect that required them to use a licensee.
Ms. Bunker, was Wesco paying T-Force employees in cash and not running it through their books? Did I see that in the documentation?
The documentation in the investigative report came from an employee at T-Force Logistics. And it looked like what they described to the department's investigator was that there was a fee per pallet of this cross-docking of $5 in and $5 out that was paid in cash to the warehouse staff. So we do have the information from a warehouse employee to the department's investigator, and that's via the investigative report. So that is my understanding, is what you just described.
So T-Force really never ran this through their books?
Hillary Bunker, again, for the record, I don't have that in front of me. It could be within the record on appeal somewhere. I'm looking for that specific statement that they ran it through their books or not. I just can't confirm that right now.
Okay, thank you. Any other questions from any of the commissioners at this point?
Commissioner Witt, if someone could answer the question, the statement of facts says on June 7th, 2021, the department's investigator was contacted by a special agent from the United States Department of Treasury, informing him they would be serving a warrant on T-Force. So Why, and what does that mean, having the United States Department of Treasury involved?
Hillary Bunker for the record. The information of Wesco's product being stored at T-Force Logistics, this was essentially how the department was tipped off that there was product on site at that current time at an unlicensed location. As the department went out and discovered that product was when they were able to speak to employees and find that T-Force Logistics had been used numerous times over the previous 2 years.
Thank you. Coming from an agricultural perspective, when we milk cows, we had rules and regulations that we followed. One of those was to make sure the milk was cold. If it was 2 hours or longer after you started milking, you could not sell that milk. And if the milk ever got to above 45 degrees prior to being picked up, it got dumped. Seems like these tobacco products are valuable, and I feel a little bit of empathy for the value of the destroyed product. But if you're dealing with a valuable product like tobacco and or milk, you got to follow the rules. The rules weren't followed. So with that, I move that we support the department in its what? Complicated.
I think you're trying to say uphold the administrative law judge's decision.
Yes, exactly. That's it. I want to uphold the administrative law judge's decision.
Mr. Chairman, I have some questions.
Could I get a second to the motion, and then we'll follow up on the comments and questions, please?
Commissioner Wren, I utter agree, so I second.
Okay. 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 I've got a motion and second on the floor. Is there any other comments or questions that we can answer before the motion is worked on? Commissioner Byram.
For Ms. Bunker, was it the first mistake by Wesco to not disclose that they were using a warehouse? There's I think a mention of an application, and they need to note if they're using any temporary warehouses on the application. Is that correct?
Yes, that is correct. That's one of the elements. Again, under NRS 370, a licensee, an OTP wholesale dealer, can use a licensed logistics company, or they can actually store their own product at their own warehouse, but they do have to apply for that with the department and inform the department of where the product is going to be located if it's not at the actual location where the business is licensed.
And is that an annual application, or did their application predate the change of law in 2020?
No, it would be beginning January 1st, 2020. This is an annual application, so it needs to be by the first of the year. So by January 1st, 2020, they needed to apply. And then again, in January 1st of 2021, it's considered a renewal. So there would have to be, again, any updates at that time.
Okay, so as a separate issue, had they used a licensed warehouse but hadn't disclosed it on their application, is that an issue where there would be a fine or any other consequence for the OTP licensed dealer?
If the department discovered any tobacco products at any sort of warehouse business location that does not hold a tobacco license of any form, that they would be subject to seizure, and the department would consider that contraband. So be it a warehouse, a business that carries tobacco and non-tobacco products, if they were to discover tobacco products at an unlicensed warehouse, that they would deem those contraband and subject to seizure as well.
And I have a final question for you. On the conjunctive test, where T-Force Logistics is claiming that they're not performing logistics as defined by Nevada statute for this particular company, but just as a temporary storage or cross-docking. there is a conjunctive test, and I wanted to know how you get around that, because I think that's a good argument. How do you get around that?
Certainly, what the administrative law judge did is she looked at 370.585. And I know that there's been reference made to two different statutes, and one that the taxpayer is referencing is the definition of a logistics company. What the administrative law judge did is she looked at how 370.585 was being interpreted, and that's the scope of license. That's what a licensed OTP wholesale dealer is permitted to, what activities they're permitted to engage in. And when she read this and then looked at the facts, she found that Wesco's interpretation of this was incorrect. So she was saying what her finding is 370.585 and then subsection 2 and D, which allows for working with another company or another location, that it authorizes a licensed OTP wholesale dealer to temporarily store the orders with a licensed logistics company and to use that licensed logistics company to fulfill orders. The administrative law judge found that the statute does not require that the logistics company perform both tasks for every order, and that if you read it that way, essentially it would create a legal loophole where a logistics company could limit its business to one activity to avoid licensure, which goes against the legislature's intent to control the chain of custody. So I know reference has been made to 370.547, but when the administrative law judge interpreted the activities that a licensed logistics company can engage in, she looked to how they're described under 370.585 and just found that in accepting Wesco's interpretation would lead to a loophole, which was not intentional.
Okay, and I'm sorry, I do have another final question. The argument about the excessive fine, the contraband being destroyed, and the Supreme Court decision or language regarding that, how is there any discretion on the part of this commission to say substitute the destruction of the contraband with a $15,000 fine or some fine that would be, you need to have your company registered, you need to disclose them, you need to follow these because we have the strict compliance, but that what we happen to find and seize at the time happens to be such an excessive dollar amount that we would then substitute with a fine rather than destruction of the contraband? Is there any authority for us to make that, use that discretion?
I don't know that I can answer that question. If one of the other commissioners want to, or chairman, or perhaps the commission's DAG.
Ms. Boardlove, could you answer that question for Commissioner Byram, please? Yeah, we can't hear you. You're on mute.
I apologize. I only unmuted the video. If you would repeat the question, it might take me a little looking through your statutes to determine the authority, but if you'll, let me see what I can do off the top of my head first.
Okay, I'll kind of summarize the question. There's an argument made by the taxpayer that the seizure of this quantity of product, which is I think $270,000 or some amount would, pardon me?
Yeah, I had heard that part. That's what.
Okay, so the seizure of that product is an excessive fine, which has support in the U.S. Constitution and the Supreme Court, and that if we were to use our discretion to say, okay, because there shouldn't be zero consequences, there should be consequences that they could then not destroy the product, but have a fine of some 15,000 or 20,000 or whatever would be an appropriate fine for them to then learn their lesson and then comply going forward with either not using this company or disclosing that they're using this company and ensuring that they have the logistics license. So enough of a consequence that they would then learn that, but not an excessive fine that we could then see this case appealed to a higher level for that reason.
So to the extent that you have the authority to impose this essentially penalty of destroying the product, then you have the authority to pull it back. Though I would caution, I know that there was questions about safety and those things. And so I would ask counsel who's more versed in that, whether you have a public safety issue that you guys want to hear or discuss. But I'd have to look specifically at your statutes for the authority to, like I said, impose that. But in general, to the extent that you guys have the authority to impose a penalty, you have the authority to modify that penalty.
Okay, that, I think that answers my question, and there's a motion on the floor, so I would just let that go through and see where we end up.
Commissioner Lippman has a question, a follow-up to Commissioner Byram. And
Go ahead, please.
consistent with Ms. Boardlove. Ms. Bunker, just for us to understand, this is, and we've seen it happen on prior occasions, this seizure and destruction of product. As Ms. Boardlove said, there must be some sort of social policy, health and safety reason. What is the reason? This is not milk that people are drinking and we need to dump, but it is a similar type of ingested product.
Certainly, within the NRS Chapter 370 statutes, there's a specific authority, one for the department to enter premises to locate contraband, but then also after the product is seized, the statutes specifically speak to the fact that it shall be destroyed. So it's 370.415 subsection 1, and that is the provision that after the department has seized the product, I will note that there is, if the department wishes to, they could auction it off, but if that's deemed not feasible or for any other reason, the product shall be destroyed. So it's not a permissive action that the department can engage in once it's been seized.
And what is the health and safety reason for this seizure of whatever product, whatever contraband is there?
I'm not sure that the tobacco products would fall under the same health and safety requirements or regs or laws that something that is ingested would be. And I'm really tap dancing around the fact that tobacco products are inherently dangerous versus certain agricultural products like milk are not inherently dangerous to be used in their normal capacity. So you have a pretty different way of looking at products when one contains things like nicotine and the other does not.
Thank you.
Are there any other questions or comments?
Chairman DeVol, this is Commissioner Bursey.
Yes.
I'm still kind of piggyback on your comments, Mr. Chair, and I'm still hung up on that $5 in and out fee at the facility. Maybe Councilor Schoenfeld can point us to the record on appeal where there might be some evidence of record keeping on that $5 for the in and out fee that was allegedly paid in cash.
Thank you. Unfortunately, the investigator did not testify regarding that. I understand that it is in his report, but there was no testimony related to that. I did object at the hearing because there were no T-Force witnesses, and it effectively becomes double hearsay. In other words, you have a warehouse employee telling the investigator and then the investigator testifying to it, and requested that we have something more reliable so we could examine what was included in the report based on alleged statements told to the investigator. There were text messages produced that did not discuss what the fees would be. So I just don't have, at this point, it wasn't part of the testimonial record, so I wasn't able to develop that and didn't foresee it being an issue, and I apologize for that. So I am kind of stuck in terms of being able to substantively respond to the question. I would like to note, though, in response to some of the previous questions, that NRS 370.523 authorizes civil penalties for violations. So there is authority for civil penalties in the event that the commission, deems that destruction of $272,000 worth of product that would have been fully lawful had it been located at West Coast Warehouse as opposed to T-Force is in fact excessive. A fine civil penalty can be imposed in lieu of the destruction.
I believe we've got the investigator that's raising his hand and can comment to this. Tina, if you can unmute him.
And Hernandez from the department, you should be unmuted.
Yes, Damon Hernandez, Chief Investigator with the Department of Taxation. Good morning. Can you guys hear me okay?
Yes, we can.
Excellent. I just wanted to add to the record something that may help the commissioners or maybe answer some of the questions specifically pertaining to the cash payments. When I was interviewing the warehouse manager who was discussing how the arrangement that they had with Wesco, he specifically said that it was done on a cash basis. And we, meaning myself, in addition to the other U.S. Treasury investigators, asked if there were any records of those transactions. And he stated that there were none. They did not run it through the normal process where if they had a customer, they would create an account in their system and they would bill them through that account. That would be the normal way that they would, conduct business and get paid for their services. However, for this specific activity, they ran it. It was just, cash and carry, cash paid to the employee of T-Force who was handling the cross-docking services at any of those occasions when that occurred. Thank you.
Thank you.
Are there any other questions or comments? Okay, Commissioner Witt, could you please restate your motion for me, please?
Okay, my motion is to support the administrative law judge's decision regarding Wesco distribution.
And I believe Commissioner Wren, do you still second that motion?
Yes, sir, I do.
Okay. On a roll call vote, Commissioner Witt?
Aye.
Commissioner Lippman?
Aye.
Commissioner Brown?
Nay.
Commissioner Byram?
Nay.
Commissioner Wren?
Aye.
Commissioner Bursey?
Nay.
Chair votes aye. The administrative law judge's decision is upheld 4-3. Mr. Schoenfeld, thank you for your time. Mr. Bitar, thank you for your time. And Ms. Bunker, thank you as well. Next item.
Commissioner DeVold, Kevin Yu is now on the phone, so I didn't know if you wanted to go back to item 4A now or wait till after item 5E.
Is everybody okay pressing forward, or does anybody need a break?
No.
Okay. Nobody chimed in, so we'll press forward. Go ahead and introduce that item for me, Director Hughes.
Yes, item 4A, Taxpayers Appeal of the Treasurer's Denial of Waiver of Penalty and/or Interest per NRS 361.4835. It's Shuju Yu for possible action, and we have the interpreter and Kevin Yu on the phone.
嗨，你好，尤先生，听见了吗？
我听到。
Yes, I'm here.
Okay, could you ask everyone to spell their name and state their name and spell it for the record, please?
OK，尤先生，请您把您的名字给我拼一下，我们要记录下来。
好，于硕巨，姓 YU，名是 SHUO 追佑。
My name is Sojuyo, SHUO JUYU, and the interpreter is Echolim, ECHOLIM, M for Mary.
Thank you.
好，谢谢。
Okay, this is your appeal. So if you, the interpreter, if you could have Mr. Yu state his case, and if you could maybe break it into parts for us so that we can be fairly accurate with what he is saying then. Thank you.
Thank you. Thank you, sir. 好，尤先生，这是今天您就是上诉的机会，请您慎重的把您的就是上诉的原因说一下，然后请您分句的说，我可以更好的翻译。
OK，就是这个房子在18年的时候，把 loan 给付掉了，然后这个 tax 之前那个税是 loan 在付的，那么把这个 loan 付清以后呢，我们不知道就是这个税呢是要自己来付，然后这个信呢又寄到这个地址，然后有一个租客他一直没有把，就是这个信有2年多他没有拿给我们，导致有一个 penalty， 2年多的 penalty 跟一个那个 interest。
好。The loan of the house was paid in the year of 2018. It was paid off. We didn't know that we have to pay the property tax after the loan is paid off, because prior to that, the tax was always paid by together with the loan. So the tax letters and mails were sent to the property, which the tenant did not forward the letter to me, which is the owner, for a good 2 years. That is the reason why we didn't know that we have owed taxes for 2 years plus the penalties. 还有什么要说的吗？
然后我收到这个信的时候，是一个好像是一个我看一下哈，我收到这个信的时候好像是一个 final， 就是一个 notice of 什么 intend to deed 这样一个信，才发现有这个税，然后我们才去，他这个房子有一个管理公司，就一个这个 property manager， 然后他才去跟那个 tenant 要这个信，就是他才去检查，发现有很多那个 penalty 这样子的，然后我们之前从来没有就是晚付这个 tax 过。
Okay, when I received the letter, it was a final notice. The notice intend to the deed. Then I realized that there was this outstanding tax. This property has a property management company that is managing it. We went to the property manager. They went to the tenant, and that was when I realized that there were multiple letters, mail sent to the address that the tenant didn't forward it to me. But by the time we realized about this issue, there was already a lot of penalties incurred.
总共是3730.40，
多少？
这个总共的 amount
总共是多少
？3738块，3738.4。
Okay, the total amount is $3,738.4 US.
然后我收到这个信的时候，我就马上就付掉了。我打电话给这个就是内华达的那个就 property tax 的这个部门，就一次就把它付掉了。然后我问他是不是可以就是申诉，申诉就是 waive 这个 penalty 和那个 interest， 然后他说让我就是把那个就是所有的资料就证据就发邮件给他们，然后我发了这个跟这个租客的合约，还有就是我们什么时候 pay off 的一个 loan 的公司的一个证明，但是最后呢，这个 Office of the County Treasurer 呢，只退了151.66，他说是退了 partial 的，
退了多少？
只退了一部分，只退了151块6毛6。
OK，
他说是他只退了18年到19年第3到第4这个，他说是 third 到 fourth， 2018到2019年只是这一个 quarter 好像。
The total penalty was 3,738.4. When I received the letter, I immediately paid the old amount to the property tax. I asked the property tax department if I can appeal my case to waive the penalty and the interest. They told me to send in the evidence. I mailed in my tenant contract and also the proof of the loan payoff from the bank. The Office of County Treasurer only refunded me $151.66, which is a partial refund, I was told. It was a refund for the year of 2018 and 19, third and fourth quarter.
Miss, is it Echo? Miss Echo?
Yes. Yes.
Does the taxpayer understand just because their loan is paid off, that doesn't extinguish the taxes? Do they understand that?
你能理解说，即使您的房贷还完了，你的这个房产税还是你的责任的，你理解吧？
我理解，但是可能完全就是忘记了，因为以前这个房子付了十几年的那个 loan， 就完全忽略这个事情了，也是第一次发生。然后我算 ，OK。
I understand now, but then because I was paying the loan for the property for more than 10 years, and then the property tax has always been paid together with the loan. So I have forgotten that I needed to take care of the tax myself.
Okay, thank you. Is there anyone from the department that has any commentary on this?
Commissioner Lippman, property taxes need to be paid timely, and in order to motivate and inspire real estate owners in Nevada to do this, and not just in Nevada, but basically across the country, the penalties for late payment are just traditionally very onerous, and the burden is really on the taxpayer. While I appreciate he didn't understand, he has the duty to understand how he needs to pay his taxes, and the fact that the tenant didn't forward the mail, that's something that as a landlord, you just have to manage. So I am going to move to uphold or to deny the taxpayers' appeal of the treasurer's denial of the waiver of penalty and or interest. And I'm confident that this taxpayer will be paying their property taxes on a timely basis. So sorry for the onerous penalty, but it's how the system ensures that people do pay their property taxes.
好的，首先要跟您解释一下，房产税是需要及时缴纳的，这个是每一个公民的这个拥有房产的这个责任。那个罚款逾期的这个逾期的这个罚款呢，是提醒大家所有的公民都要就是及时缴纳这个房产税，不然的话大家都不了解自己的义务了。作为一个房东，你有这个义务，首先去了解管理你的这个租客那里所收到的您自己本身的信件，这是你需要去进行的工作。纳税也是你的责任。所以呢，我要再次提醒您，作为一个公民和作为一个就是房产的这个房东，你需要有这个义务和责任去确保这个税收是交的，所以我们拒绝您的上诉然后呢，您 我相信你以后也会按时的递交你的这个地税的，所以您的上诉被拒绝。
但我想再跟他讲一下。
Can I have something to add on？ 好，您说。
就是这个 penalty 加那个 interest 总共是1054块5毛8，就当时我付这个1笔3000多的时候，它在那个网站上是有显示的。那么我是在2021年，就是今年几月份？我看一下，今年3月份付的。那么他就是说他这个 penalty 跟那个 interest 如果退的话，我不明白为什么他只退了2018到2019的这个第3个，就是这个 quarter， 后面我应该是就是及时付了嘛，就是那个今年的我应该是及时付了，他今年他没有，就只退了很小的一部分，就是那个 quarter 了。
The penalty and interest is amounted to about 1,054.58. This was shown in the website when I was paying for the old tax and the penalties in 2021 March. When I received the refund of 151.66, I do not understand why this portion of the amount was refunded to me only for the 3rd and 4th quarter of 2018 and 19. Of course, I did pay the subsequent tax on time.
Thank you. Actually, the county treasurer had no obligation to refund any portion of it. I think they were attempting to work with the taxpayer, and that's all they were trying to do. They had no obligation whatsoever.
OK， 你应该知道这个郡的这个康迪他们是没有任何的这个义务需要退这个地税给您的，他们退给您就是可能就是给你一个鼓励，因为你是第一次嘛，所以他有退这么一个部分给您，就是给您的一个算是一个支持和鼓励了。
好，我知道了。
OK，
谢谢。
I understand. Thank you very much.
Thank you. Okay, I've got a motion. Is there a second to that motion from Commissioner Littman?
Commissioner Bursey seconds.
好的，刚才的那个驳回上述的这个建议，有人复议吗？他们有人复议了。
Okay, I've got a motion and second on the floor. Any other discussion?
还有其他要讨论的吗，于先生？
没有了。
Nothing else.
Thank you. All those in favor, please signify by saying aye.
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 大家都
Anyone opposed? Okay, the taxpayers' appeal has been denied. Thank you very much for your time, Mr. Yu and
谢谢。
Ms. Echo. Thank you.
谢谢尤先生您的时间，您的上诉被拒了，然后谢谢您今天的时间。好 ，Thank you, no problem. Thank you very much.
Mr. Chairman?
Thanks.
Yes.
Mr. Chairman, can the interpreter excuse herself?
Yes, you may. Thank you so much.
Thanks.
Take
Thanks
care.
for having
Thank
me.
you for your help.
Bye-bye.
Commissioner Brown.
I apologize, Mr. Chairman. I have a disclosure to make before we take up the next item regarding the tax bulletin. I'm related to an individual that holds a wholesale license in the liquor industry in Nevada, and therefore I will not be participating in the discussion or the vote on this matter.
Thank you. Director Hughes.
Item 5E, discussion and possible approval of tax bulletin 21-0001 regarding the shipment of liquor directly to Nevada residents, statutory changes brought by Senate Bill 307 in the year 2021. I will be presenting that item today to the commission. So good morning, Chairman DeVold and commissioners. Shelley Hughes for the record. Today I'm bringing tax bulletin 21-001 for your approval. NRS 360.133 authorizes the executive director to prepare technical bulletins to educate the public on issues related to their businesses and the taxes administered by the department. Pursuant to that statute, a technical bulletin may include information that is applicable to a specific industry and is intended for information purposes only. The bulletin before you today is applicable to the liquor industry and provides information and guidance regarding the shipment of liquor into Nevada directly to Nevada residents. With the passage of Senate Bill 307 in the 81st legislative session, as of July 1st, 2021, a supplier can only directly ship 12 cases or less of wine to Nevada residents per year for personal or household use. This is a change from what was previously allowed to be shipped into Nevada to a Nevada resident. The bill removed the word liquor from the statutory language and replaced it with wine. The bulletin also defines a designated agent and indicates that a supplier can designate an agent to sell its products to importers into Nevada. The agent must be registered with the department as a supplier. We have not received any opposition to this bulletin. And with that, I ask that you approve and adopt Tax Bulletin 21-0001. I have excise tax staff here with me today, and we are available for any questions you may have.
Director Hughes, was there a workshop completed on this? Was there any input from the industry at all? Just curious.
With tax bulletins, we are not required to hold workshops as we are with regulations.
Gotcha.
So there has been some conversation with industry members as they inquired on how we were going to implement SB 307. And so this technical bulletin is actually a result from those discussions.
Okay, thank you very much. Is there any questions of Director Hughes?
Mr. Chairman?
Yes.
Commissioner Rigby, on page 2 of the document under the heading retailer defined, the first word is incorrect. It says pursuant instead of pursuant with a T. Sorry, that's nitpicky, but.
Thank you, Commissioner Byram. We'll get that corrected.
Thanks.
Commissioner Lippman, I'm trying to understand the change in the law. And so basically the word wine is replacing liquor. So could you explain that a little bit more?
We have Jolynn Smith, the tax manager for Excise Tax here today.
For the record, Jolynn Smith, Tax Manager, Department of Taxation. During the legislative session, there were concerns about liquor, beer of the month, that type thing being sent into Nevada. So the industry, the wholesale industry and others got together and they wanted to make it very clear. It has been their interpretation all along that it could be only wine, but based on the wording of the statute, it was liquor, which was opened it up to everything. So the industry came together and decided to make it very clear at that point that it could only be wine.
Thank you. So this narrows the scope.
Yes.
Okay. Although in substance, it doesn't narrow the scope. That was the understanding before, but just adds clarity to the.
Exactly. It was
Thank you.
to add clarifying language.
Yep. Thank you very much.
Are there any other questions on the bulletin? Is there a motion for approval?
Commissioner Lippman will move to approve the tax bulletin 21-0001 regarding the shipment of wine directly to Nevada residents.
And Commissioner Byram, second.
Got a motion and second. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, bulletin is approved. Informational items.
It's item
Use.
6A, penalty and interest waivers granted by the Department for Sales Use Tax, Modified Business Tax, and Excise Tax. This is for the Commission's information only. And item 6B, approval and denial status report log for organizations created for religious, charitable, or educational purposes. Again, this item is for the Commission's information only.
Are there any questions of the department on any of the informational items? Seeing none, we'll move into your briefing.
Yes. First, I wanted to introduce the new management analyst over the executive review section. Her name is Sarah Glazner. As many of you know, George Ritz retired in June, and Sarah will be taking his place. His position or her position oversees the hearing process, and you may occasionally see her testifying on appeals for late hearing requests. The next thing I wanted to provide you with is an update on the Mbt refunds. As you may recall, at the beginning of this process, the department estimated that approximately 80.3 million refund checks would be sent out to 37,000 taxpayer accounts. Currently, we have issued 52.4 million refund checks to approximately 27,000 accounts. This leaves approximately 27.9 million remaining to be sent to approximately 10,000 accounts. For these remaining accounts, taxation staff will continue to work on ensuring the completeness of taxpayer records and obtaining valid addresses. As these records are updated, refund checks will be issued on a monthly basis during the weeks of October 11th, November 15th, and December 13th. We anticipate getting most of these refunds out by the end of the year. We are asking taxpayers to call our call center if a refund is expected and it has not been received to date. Another matter that was recently brought to our attention is our compliance with the Streamlined Sales and Use Tax Agreement. Some of you may have heard that Nevada was recently found out of compliance with Streamlined Sales and Use Tax Agreement due to a Senate Bill 440, which provides a sales tax holiday for the National Guard members. The Streamlined Governing Board is meeting this week for final action, and I will keep the commission updated on the Governing Board's decision and how Nevada will be moving forward to correct this issue. At the last commission meeting, there were several questions regarding the refund of live entertainment tax to the Desert Research Institute. Several governmental entities are included as one entity with a single Nevada taxpayer identification number. Desert Research Institute is not registered for the live entertainment tax, but is listed as the main entity on this account. All the entities on this account are in our system by location number. Desert Research Institute is one of the entities listed as location number 002. And as a result of its modified business tax registration, Desert Research Institute also became the main entity of the account as location 000. The credit refund requests for the live entertainment tax were actually submitted for location 004, which is Sam Boyd Stadium, and location 005, which is UNLV Thomas and Mack Center. These are the entities that will be receiving the refund, not Desert Research Institute. And lastly, to end my briefing, I wanted to let the commissioners know that this week the department is having a staff appreciation week. The department could not do what we do without each and every one of our staff members, and I want to thank everyone for their hard work and dedication. The department has awesome staff, and I want to make sure they are recognized here today. And that concludes my briefing.
Thank you. I want to pile on or piggyback, whatever you want. The department staff is phenomenal. Just everybody we deal with is so amazing and smart and just really well prepared and nice people. And, you know, I just want to make sure that everybody knows that I think every one of the commissioners feels the exact same way. And we just really appreciate everything you guys do for us. So thank you so much.
Mr. Chair, this is Commissioner Bursey.
Yes.
I had a follow-up question to Ms. Hughes. Part of your report was that Nevada's been found to be out of compliance with uniform streamlined tax with respect to the National Guard sales tax holiday. Could you explain that, please?
Yes, definitely, Commissioner Bursey. So the sales tax holiday for the National Guard was passed at the last legislative session. And we are found out let me go back, in the sales and use tax agreement that under section 322, they have certain requirements for a state to have a sales tax holiday. There's 4 requirements, and we were found out of compliance with 3 of them. The first requirement was that the bill does not define tangible personal property to be exempted. That's consistent with the Library of Definitions in the agreement. The second where we were found out of compliance is the bill applies an entity-based exemption that the agreement does not allow. And the third area is the bill requires the seller to obtain an exemption certificate from the purchaser, which the agreement also does not allow. So the legislative language requires that the seller obtain an exemption certificate in order for the National Guard member to be exempt during the sales tax holiday. So Streamlined found Nevada out of compliance with the agreement. We find out this week what the final action will be from the governing board, but Nevada will have to move forward likely at the next legislative session to fix this issue.
Mm-hmm.
Thank you, Shelley.
You're welcome.
Any other questions or comments from commissioners?
Mr. Chairman, I have a question for
Yes.
our director.
Yes.
The last the legislative session earlier this year, there's a new excise tax on mining gross proceeds. Can you give me an update on the forms and instructions, any regulatory workshops, and where does that stand?
Yes, Commissioner Bursey, we're here at the department, we're continuing to work on implementing that bill, and we're in the process of getting those forms drafted and any regulation language drafted, and we will be notifying the commissioner as to the status of where that is. And going forward, we'll be presenting notices to industry to participate in those workshops.
My follow-up question, this was passed and it's retroactive to January of this year, and many companies have to file provisions and disclose what the tax is, and they're asking me, my clients are asking me, how do they go about doing that without, instruction on how the law is going to be interpreted? And I'm just curious if any kind of communique can go out to the mining industry to give them some instructions on where it is.
Yes, definitely. We will be working on getting out some notice. We are working with the Attorney General's office on that currently.
And is this going to be under the excise department rather than the locally assessed?
Yes, it is under our excise department. Nadia, who oversees our commerce tax, will also be seeing the mining tax.
And Nadia's last name is what?
Vishenko. And it's spelled, I believe, and forgive me, Nadia, if I get this wrong, Vasheko.
Thank you.
You're welcome.
Any other questions or comments from commissioners?
Commissioner Lippman wants to second the motion from Chairman DeVol to celebrate and applaud the incredible staff at the Department of Taxation. I am routinely impressed, and I have very high expectations by the integrity, the dedication, the commitment, and the thoughtful interaction with Nevadans to help our entire state collect and the proper amount of taxation so that we can all enjoy being Nevadans.
Well said. Okay, with that, our next meeting is December the 6th at 9 o'clock. We'll send you information regarding that. This time, is there any public comment?
Anyone with public comment, please dial *9 to be put into the queue. We do have Aaron Bradley. Mr. Bradley? Mr. Bradley, do you have public comment? You have your hand raised.
Yes, I'm sorry. I'm sorry if I'm speaking out of turn. I'm just curious if my notice for the security waiver will be discussed on this meeting. I was under the assumption it would be.
I'm guessing it was done under the consent calendar. I apologize. Commissioner Brown, thank you for reminding me to remind people, if you've got something on the consent calendar, it's previously approved in one fell swoop. So, Mr. Bradley, I apologize. It was previously approved. And we've wasted a couple of hours of your day, and I apologize for that.
Oh, it's not your fault. It's my misinterpretation, but I thank you for your time.
Thank you, sir.
Thank you.
Public comment?
I do not see any other public comment.
Okay. Are there any items for future agendas?
Mr. Chairman, I would just want to thank the department for the memo on the DRI. That was a question that I raised last time, and I appreciate the follow-up this meeting. So thank you to Ms. Hughes and her team.
And we continue to appreciate your staff. How's that?
Thank you.
Thank you, Commissioner Brown. Okay, without anything else, our meeting's adjourned. I will see everyone on December the 6th, and thanks to everyone for your time.
Thank you.
Bye.